At fall town meeting last October 2023, an article to fund a town centre reconfiguration passed by a narrow margin, less than a percentage point. A 2/3 majority, 66%, was needed, and 67 voted in favour. 11 years prior, for an eerily similar article, town meeting reps also voted in favour, with 69, to fund a centre redesign. At that time, 11 years ago, George Similaris successfully ran a campaign to grant all registered voters in Billerica a chance to have a say. A citizen petition resulted in a referendum which overwhelmingly overruled the town meeting vote. A record voter turnout of 40% obliterated the town meeting vote by 9,084 votes. Those were opposed to just 1,467 in favour. That's 14%. Compare 69% to 14%. Who exactly do the so-called town meeting representatives represent? On that same note, 3 so-called Democrat selectmen prefer oligarchy, government by a few, over democracy, government by the people. The scenario seemed to repeat itself this year with an even narrower vote until last week, Thursday, October 26, when 3 selectmen voted to throw out a petition with 2,299 citizen signatures that were certified. In a Lowell Sun article a few weeks before that, town manager John Curran had joked it was like we are watching the same movie again.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Chairman, the first item on the agenda is to set the date and vote for a special election in reference to the Town Center referendum petition from the annual 2023 annual fall town meeting, Article 14. So, Mr. Chairman, I'll make a motion to accept the petition as presented.
Second.
All right, motion and seconded on the petition. I'd like to talk on it. Does anybody want to talk on it? I recommend that this petition be denied.
Mr. Chairman?
No,
No open mic here tonight.
because we decided that there's no open mic.
Meeting and it deserves an open mic.
So I appreciate that, but there's no open mic and there's no public comment tonight. I'm sorry.
Here right now. I'm telling you right now.
Selectman Rosa.
I'm out of here. You're not throwing me out. If this petition is denied, it'll be in court. If we worked hard, the people knew what they were signing, and I'll tell you, after this is over, there's April elections coming up, and whoever stops this petition will be voted out for sure, guaranteed.
There's no public comment, please. That's the last time I'm going to say it. There's no public comment. So you just made a point which I think is good, and I respect the process, and I respect those that voted. But the petition is, in my opinion, is flawed, and I'd like to hear from the other members of the board. We have a motion and a second. All in favor of the petition?
Aye.
Aye.
All opposed? Aye.
Court is open, you may be seated.
Yeah, that's huge. I didn't have any exhibits in mind. I just got this.
Now, the matter before the court is docket number 2381 CB 3248. Dina Favreau versus John Burroughs as the Board of Selectmen of the Town of Billerica and others. Parties could please introduce himself to the court and for the record, starting with the plaintiff.
May it please the court, Attorney Roland Millard for the plaintiff. My client is seated to my left. May she join me at council table?
Yes.
Thank
Yes,
you,
Your
Your
Honor. Good afternoon to you both.
Good afternoon, Your Honor. Deborah Ecker for the defendants, and with me is Attorney Marlies.
Okay, good afternoon to you both. All right. Thank you all for coming in. I hate to prejudge a matter, but I suspect I think both sides might not be happy with my initial thoughts on the filing. So we're here today for a motion for preliminary injunction. But it did occur to me, so Attorney Millard, I'll turn to you first. But looking at your complaint, it's obviously a mandamus complaint and also asked for injunctive relief. It seemed to me that the injunctive relief is either an alternative remedy to your request that I, through mandamus, issue an order to the town of Billerica to have that vote. And it seems that the other aspect of the injunctive relief would be to somehow prevent the town of Billerica from moving forward on the initial town meeting vote. And it seems that, so in other words, that would typically in and of itself lead to the typical course in litigation, and there'd be eventually probably a motion for judgment on the pleadings once all of the parties have exchanged discovery and the like. So nothing in your original complaint, counsel, or nothing has been subsequently filed that I've received at least that would lay out a preliminary injunction. In other words, I haven't seen anything as far as irreparable harm or the balancing of the harms and the weighing of the government interest I would typically see in a motion for preliminary injunction. But I do know that you asked for a short order of notice. So I guess my first question to you, Attorney Millard, would be, is it your understanding that you are seeking a preliminary injunction at this point?
Only, Judge, as to prior to about the $15 million to bond the project. My understanding is they would have to retain bond counsel, and bond counsel would have to do the underlying work, and there'd be a fee paid to bond counsel. So to prevent them from retaining bond counsel and from rolling the ball on doing the groundwork in order to bond the project, the article allows for, I believe, $15 million. We're seeking the injunction to prohibit them from moving down that road in case the writ of mandamus issues and the town votes to override representative town meeting's decision, and that way there would be no need to do the bond issue or to vote the project because the town would have killed the matter in the first place. But we're seeking to make it as economic as possible for the town so that they don't walk down that road to start to initiate the bonding of the project.
So, Attorney Millard, that seems to make complete sense to me, but I guess my question would be, wouldn't you need to file a separate motion for preliminary injunctive relief and to lay that out?
Judge, but I put it as a prayer for relief, and in the motion on the short order of notice, I believe I said I would like a hearing on the prayer for relief for the injunction, because if I had left it until the complaint was over, the prayer for relief is in the complaint, and if they had gone down the road, the argument could be made, well, we've already started walking down the road, Judge, and we haven't had the election yet, so can we continue with the bonding project at least until the results of the election are in? So my client would like to make it clear that the town should be prohibited. If the town wants to say they will not initiate any action relative to the bonding of the project, then my client would be satisfied with that as long as they represent it on the record in court. My client would be happy with that. But if they aren't going to do that, then we would ask for an injunction enjoining them from taking any steps to bond this project until the results of the election are held, should the court see fit to issue the writ of mandamus.
All right, I certainly think it may or may not be wise for the town to do that where there's pending litigation. It might be wise to not go for it on getting the bond. But again, this does come back to what I see as a weakness from your perspective, counsel, where I haven't heard anything, and I assume maybe you'll make the oral argument today and the assistance of your client, and maybe we'll even have testimony. But I'm not sure what to issue such an order, which would be an extreme order. As you know, preliminary injunctive relief is an extraordinary remedy with the court. I would need to hear some irreparable harm and then balance the harms and balance the public interest. And just off the top of my head, I'm having difficulty understanding what the irreparable harm would be to your client if the town went forward with that, was it a $14 million bond, $15 million? 50. 1.5. So it is your motion. How would you satisfy irreparable harm? What evidence do I have?
Well, the people of the town of Billerica would be paying for the work to get the bond going. And as a taxpayer, my client would be jeopardized because the money she pays in her taxes would be going for this. It would be, quite literally, it would be wasted money. And although the courts tend to think that financial issues are not really irreparable harm, in this particular case, the bond is tied to the writ of mandamus for an order to compel the election. Fast forward a little bit here. The town charter does not allow the select board to opine on the sufficiency of...
No, I get that. I get that.
So if they walk down the bond road and the court finds that you have to order this and the election comes back that the town doesn't want it, then that's just wasted time and effort and wasted money. And I do not see any set of circumstances based on the town charter and prior history of the town on these petitions where they would have a likelihood of success here on the writ of mandamus request. Essentially, my client will testify that in 2012 and 2017, there were two other petitions of a similar nature where the wording was the same. And in the 2012 one, town council was a sole practitioner who ruled to the board that it is valid, it's adequate, and they had a referendum on it.
But now you're getting to success on the merits of the mandamus. So before you get into that, I'm still having great difficulty. As you know, the case law, you referenced it just now, for a preliminary injunction, if financial remediation can ultimately be a relief sought and can be satisfactory, then there's no preliminary injunction. So you haven't really given me anything other than the fact that the town may lose significant portions or all of the 15 million or whatever they spend in an effort to get, well, they wouldn't lose the 50 million. No, but they would lose whatever money it would cost to get that bond.
And based on my experience with the Drake Water Supply District, it would be a considerable sum to retain bond counsel and have them start to do the work to write up the bond issues.
But as you pointed out at the beginning of the hearing on council, isn't that, doesn't the town of Billerica run that risk in going forward with this, where there's pending litigation that, you know, is a point you'd make, and then the point when I question counsel for Billerica, you may be correct and you may prevail, your client may prevail on the mandamus as far as whether or not the charter would require the election to be held on this matter. So it would behoove the town, you would think, to not go forward until that issue is resolved. But again, as you know, it's an extraordinary relief for me to issue a preliminary injunction. You may ultimately be successful. You may be likely to succeed on the merits, which is, you know, step one of a preliminary injunction. But I'm having real difficulty finding step two, not even step 3 and 4 we haven't gotten to yet. But so your only argument is that your client, as a resident of the town of Billerica, may secondhand be out financially because the town may have wasted whatever money it takes to procure the bond.
Well, I would also judge there were almost 4,000 signatures on this petition. The town clerk stopped certifying it when she got to a number to get it through, and there was a cushion in case there was a challenge. She stopped certifying. And as a tactical issue and being able to deal with a client, I only wanted one. I didn't want more than one. I only wanted one person to be the plaintiff. But if you take the people who signed as also being involved, there are almost 4,000 people who signed this petition to vote on this project, and one would suspect they didn't sign because they were in favor of it. So there are almost 4,000 resident voters and taxpayers in the town of Billerica who are also going to be adversely affected by this, who don't want this to happen.
But what is their irreparable harm?
Once the money's spent, it doesn't come back, and there are other things that the public purse has to fund. And they spent the money on this, it's gone, and if something else comes up, money's got to come from somewhere, and it's going to come from the people who signed that petition. That's where it's going to come from. It's as simple as that. It doesn't grow on trees, and it doesn't fall like pennies from heaven. If you spend it on this, and it turns out to be a waste of time and money, theoretically, that's fine, and the people who authorized it will answer up at the next election. That's fine and dandy, and that's good for a civics class, but it doesn't deal with the people who are paying the bills. And the people who are paying the bills do not want this spent unless and until the project is approved at a voter referendum.
What about what I'm inevitably going to hear from counsel for the town, the aspect of mandamus, and I think the case law is correct, where there has to be And I think the standing argument, I haven't heard from counsel yet, but I'm less adopting of the standing argument. I think your client has standing because she's a resident of the town of Billerica, so that gives her some, in my view, some automatic standing. But as you know, the mandamus law does require some additional harm in addition to that.
She's also a member of the representative town meeting.
Well, that's also another interesting point that the defendants make here that I found. She voted in favor of the thing that she's now trying to have the town vote on and potentially reverse.
Well,
so what's her harm, her particular harm as a named plaintiff?
Her view on this is that she was elected from her district to be town meeting. She heard the argument. She voted yes. Then after it was voted on, she got some calls from some constituents. She thought about it, and she was wavering. But then she thought that they should have the right to vote on it because she's out there and she comes up for election as a member of town meeting. So she's not afraid for the people of Billerica to go to the ballot and voice their opinion. She may be a representative of representative town meeting. It's similar, Judge, you're in Congress. You vote yes. You stand up to your constituents every 2 years. They don't like what you did. They vote you out. She'll be voted out if they don't like what she did. But she feels that they have the right, whether they're going to vote to back what she did at town meeting or they're going to oppose it. The charter says that if they have enough signatures certified by the town clerk, the select board shall, not may, shall schedule a special election. There's nothing in 2-13 of the town charter that allows the selectmen, the select board, to pass judgment on the sufficiency of the petition. These things have to be read with liberality, and every doubt has to be resolved in favor of the electorate, in favor of the voter. Here, this petition that went forward in 2012 and in 2017 used the word amend. In 2012, private counsel was town council. They opined that it was good to go. In 2017, same thing. KP Law was the town council. They said it's fine, it's good to go. Now they're saying the language here is insufficient. But again, the town charter, which controls, does not allow them to comment or opine on the sufficiency of the petition.
So
as long as
I
it
don't,
puts them on fair notice about what the petition's intent is, they have to order the special election.
Jim Laird, I don't want to interrupt you. I think you're making very valid points. And as I hinted in the beginning, the fact that neither one of you may be happy with what my thoughts are, at least initially, without hearing the full argument. But I need less. You're arguing likelihood of success than merits, and I think it's a relatively strong position. The weakness that I see with your filing is the irreparable harm and the injury, and whether or not your client has full standing under the mandamus law to file this action. But my real problem is with the irreparable harm. And then the balancing of the harms, obviously, and then the public interest. And it sounds to me like your argument on the irreparable harm is that the taxpayers will end up paying some amount of expenses related to getting the bond, and that money will never be able to be recovered back.
Yes, that's about it, Judge. But do you want me to talk about the standing issue?
Sure, go ahead.
I have a case, Judge, Nicholas versus City of Marlborough. It's a Superior Court case from 2014, MICV 2013-05608. It says plaintiffs have standing to seek release in the nature of mandamus under General Laws, Chapter 249, Section 5. The so-called public right doctrine allows citizens who otherwise would lack standing because they themselves have not suffered any legal injury to seek relief in the nature of mandamus to compel the performance of a duty required by law. And in that and in another case, Citizens for Competitive Massachusetts versus Secretary of the Commonwealth, 413 Mass 25, 1992. Although they were talking about Article 48 of the Massachusetts Constitution, the language is very effective here. It says Article 48, just like the Billerica Town Charter, created a people's process. It was intended to provide both a check on legislative action and a means of circumventing an unresponsive general court. It presented to the people the direct opportunity to enact statutes regardless of legislative opposition. It projected a means by which the people could move forward on measures which they deemed necessary and desirable without the danger of their will being thwarted by legislative action. And that's exactly what happened here. Granted, they're talking about the Massachusetts Constitution, but you substitute Constitution for Billerica Town Charter, substitute General Court for Select Board, the exact same logic, the exact same conditions prevail here. And that's why My client does not concede for a moment the defendant's perspective that she doesn't have standing. But should the court feel that they do make a valid argument, then she feels that she has valid standing under the public policy rule.
What about the cases, and I thought I looked one up and it looked like it was still valid law, but it was the town of Sudbury versus MBTA, that to have standing in any capacity on a mandamus, a plaintiff must show that the challenged action has caused the plaintiff injury.
I would say, Judge, the town charter says that they have to order a special election. So I would say she has suffered injury. One of her rights has been denied her right to vote in a general election where a valid petition was presented to the selectmen who do not have the authority to pass on the sufficiency of that petition. Their obligation is in the town charter. They can't move beyond the town charter, and it's mandatory. They have to order a special election. So her harm is that her rights as a citizen under the town charter are being circumvented and denied by the select board. So where does she go for relief? She has no choice but to go to the court. Or for her to say, well, I guess they did it. All they need to do to succeed when they're doing something they shouldn't do is for someone not to stand up and say, you can't do that. And if you don't do what you're supposed to do, I'm going to go to somebody who has the authority to make you do what you're supposed to do. And that's what she's doing. That's how the whole system is set up. There is a safety valve here. There is a mechanism of relief available for people situated as my client, and the other people who signed that petition are so situated. Rather than rioting and taking over town hall and throwing them out physically, they come to the court and say, here are our papers. Here's what the law is. Here's what the town charter says. We would like you to use your authority to issue a writ of mandamus to order them to do what they're supposed to do. The town charter is only roughly 40 years old. It's 1973, I believe, 27, 23. It is 50 years old. Relative to most documents in Massachusetts, founding documents, it's a relatively new document. It was probably thoroughly debated, hours of time spent by volunteer citizens on the charter committee. And if they'd wanted the selectmen to opine on it, it probably would have been in the town charter. I believe it's Exhibit B or C of the packet. Part C of the 2-13 of the town charter has to deal with the petition.
No, right. I read that.
Yeah,
but
later on, they try to conflate them. When the ballot is printed, the question presented has to be substantially the same as that was presented to town meeting. But in the part about the petition itself, it just says they have to have a petition, it goes to the selectmen, they need 5% of the registered voters to be certified by the town clerk. Those are it, that's it. Those are all the bills and
whistles. Right, I know, you're arguing likelihood of success of the merits again, and I'm having less problem with that than I am with, I think you made at least a plausible argument on standing and harm, but I still think you have an uphill battle here on irreparable harm, because I've heard really nothing that's irreparable.
Maybe on the injunction, Judge, but certainly on the writ of mandamus.
Well, the writ of mandamus, I think I want to give defense counsel a chance to convince me otherwise, but the writ of mandamus seems that, I'm sure there'll be a motion to dismiss, but that seems like it's going to go the course of a motion for judgment on the pleadings, and a court will make a determination as to whether or not the writ of mandamus issues. I'm not suggesting you don't have, at least in my initial view, a plausible case. I just think the preliminary injunction at this point with what I have is a little bit weak. Doesn't mean you couldn't have information that you glean later on from your client and others in the town that suggests to me that something is imminent that's going to happen that is going to create irreparable harm. In other words, oftentimes in cases like this, it's something to do with the environmental impact of a project like this or something like that, which doesn't seem to be applicable here. But I'm just not hearing very much on irreparable harm.
I would have nothing more to contribute, Judge.
Okay. All right. So, counsel, I hate to steal your thunder on a lot, but as you can tell, I'm being inclined to not find that the plaintiff has met the burden of irreparable harm such that I would issue a preliminary injunction. But as you can tell from some of my questions of counsel, I do think as to likelihood of success on the merits, I do think there's something possibly here. And what I mean by that is just from my initial review, it seems to me that clearly there is that charter provision that does allow for if within 7 days you have 5% of the populace that signs a petition and gives addresses, then that's submitted by the town clerk to the Board of Selectmen, and then there does have to be an election. It's my understanding that the Board of Selectmen drew issue, I think, with the word amend. and a number of other things. I will tell you that when I looked at what I saw, it seemed to me to be a little bit, for lack of a better way to put it, straining at gnats. In other words, that maybe the petition wasn't written perfectly, but it seemed pretty clear to me that the petition was challenging the vote of the town meeting relative to the renovations to this town center. And I didn't see anything in the charter that laid out, as council pointed out, with different parameters as to what that petition had to have. So anyway, that's just some of my preliminary thinking here.
And it is preliminary, of course, because we respectfully disagree. First is the preliminary injunction that we're here for today. I agree with Your Honor, there's no, and we're arguing against ourselves because there was no motion that was filed with all, the 4 factors. But there is no irreparable harm. There's clear case law that economic harm is not sufficient for irreparable. So for the purposes of today, an injunction shouldn't issue. In fact, bond counsel is not paid by the town, but only paid at the issuance, from the issuance of the bond. So even if there were any economic harm and that were sufficient, which it's not, the town hasn't incurred that and won't incur that. That being said, I want to focus on standing, and I know Your Honor is inclined to find that the petitioner has standing.
Well, at this point, again, I'm sorry to interrupt you, but in other words, I don't have a motion to dismiss before me. I think standing is an interesting issue, but I think there's at least a plausible argument that she has standing. But again, purposes of today, and I'm not trying to kick the can down the road, but for purposes of today, I'm not inclined to issue the preliminary injunction. But if you want to be heard on standing, I'll certainly hear you, or if you want to set it up for a motion to dismiss based on standing or otherwise, I can do so. Whatever you want. I don't mean to cut you off. I just want to.
No, that's fine. I was suggesting, Your Honor, give a short date for us to file either a motion or dismiss. I mean, there are no facts in dispute here, realistically. So for a motion for judgment on the pleadings, whichever Your Honor prefers, and then we can discuss again, the standing or the issues why we believe there is a likelihood of success. And at that point, judgment on the pleadings would be why we succeed and why mandamus should an issue. Because as Your Honor pointed out, or to bring a mandamus action, the petitioner, which is one single plaintiff here, does need to have a particularized harm. It can't just be that one individual comes in and challenges.
But doesn't Attorney Milliard make a relatively valid point that, as a citizen, and you have this provision in the town charter, and you think it's going to happen, and you're aggrieved by what you think the town is doing or not doing, and isn't that harm in and of itself if they believe a right within the charter of the city or the town is not being abided by?
No, and the individual plaintiff in this case law to this effect just can't come in and challenge something that a town government does, for instance here. And so there is in the mandamus case law that's out there that there does have to be a particularized harm. There is a public duty rule, which my brother referred to, but I don't agree with his interpretation as to what that says. That parses procedure versus substance. And so we can put that into a motion for judgment on the pleadings, why we believe that's not applicable and standing doesn't apply, particularly here when you're seeking a mandamus action, which, as Your Honor knows, is an extraordinary remedy.
Right, as is a preliminary injunction, obviously. But, well, let me turn to the parties and what you would prefer. So I'm not going to issue a preliminary injunction for the reasons stated, counsel, but obviously if new facts arise that you think would create an irreparable harm, you're free to file a motion for preliminary injunction. You know the standard. So I'll deny the preliminary injunction, but this is obviously a matter that's very important to many people in the town of Billerica, so I don't want to delay this. So the part of me that thinks we go right to judgment on the pleadings, but to almost hedge your bet, so Attorney Milliard, I do wonder if you should add a plaintiff or if we should instead go forward first with a motion to dismiss. In other words, the town is successful with the motion to dismiss based upon standing or sufficient harm understanding as it relates to a mandamus action, then we're really kind of just wasting time, because then I assume on behalf of other aggrieved residents of Billerica, you'll be filing a new complaint with a new plaintiff, when it seems to me that at the end of the day, we really need to resolve whether or not to issue the extreme remedy of mandamus and to require the town of Billerica to abide by what your client and others seem to feel is a clear violation of the charter. So I guess my point is, how do we get to that stage as quickly as possible?
If I could file a motion to amend the complaint, deleting the request for preliminary injunction and adding as many plaintiffs as...
Right, and I assume the town would still have a standing argument, but they could make that more in the context of the motion for judgment on the pleadings, but it might make it a little bit neater and cleaner, so to speak, particularly if there's an appeal. I think there's a right of amendment, at least initially, so I assume there's no objection from the town or from the defendants on that. Right. Okay. So how quickly can we get that done?
Could probably have it by Friday, Judge.
Okay, so counsel, for the defense, so are you agreeable then to not filing a motion to dismiss and going straight to judgment on the pleadings, or do you want the opportunity to file a motion to dismiss first?
No, we'll do a motion to judge. I hear you.
I think it makes a lot more sense. Okay, and I am only, this is the rub, obviously. I'm only in this session until the end of the year. Can we get this done before the end of the year, or do you think we have to push this off to another judge in January?
My clients would like it done before the end of the year, sooner rather than later.
That's fine.
Defendant,
It's
that's-
an amended complaint we can file. It has to be 9A, so we can have, the only issue would be your availability.
Right, yeah, I think I might be out that week between Christmas and New Year,
Right,
but,
because by the time I file, by the time I serve, if he files on Friday, let's say I even filed or served the motion the following Friday, he has 10 days, 7, 14, well, I guess we could do it.
okay, so what would that give us as a hearing date then on it?
The week of the 18th,
Okay,
I could do 18, 21, or 22.
and it seems doable to the parties. I don't want to put too much pressure on you all, but I think it's important to get this litigated. I'm in up until the week of Christmas, so what date is that on the calendar? I think the 21st is a Friday or something.
21st is Thursday, Judge. 22nd is a Friday.
Okay, so we could do the 21st or 22nd if we have availability.
You do like the 21st. We have all of them.
Okay, can the parties do the 21st?
21st, 2 o'clock, Judge?
2 o'clock? Okay, great, and then you'll submit the pleading sometime before that, obviously.
Right.
Other than 9A?
Yes.
Okay. Okay, great.
Just the one thing, and maybe gave you a thumb drive,
Yes.
so I might refer to that unless you want me to.
No, you don't need to do it again. I'll keep all this. All right, anything else, counsel, we can address today?
No, Judge, thank you.
All right, thank you all very much.
This matter is continued to December 21st at 2 o'clock.
Thank you, ma'am.